Greetings from very sunny Rome. I'm going to share my screen, and I am, please do confirm me that you can see my screen well. Oh, good. All right.
Yes, okay, thank you.
Fantastic. So first of all, I would like to acknowledge the fact that this presentation is shared from two sides with Paolo Giardullo. I'm currently not yet at the University of Padova, but I'm going to present a work that will be soon kicked off at the University of Padova from February 2026, supported by a FISSPA grant, which is a national research, like Ministry of Research and Education funding, which I will soon start indeed. And the topic is surrounds the role of personal narratives in climate litigation. I would like to praise all the contribution that preceded me, but at the same time also stress that you may feel that this is somehow quite far from the rest of the discussion, because I will bring you throughout a journey in the world of climate litigation. So really court cases that deal with assessing climate impacts on real people from the perspective of identifying responsibilities. I'm currently affiliated with ASUD, which is an NGO which launched the first climate case in Italy, Giudizio Universale. I speak from the perspective of an environmental and climate lawyer, but also a researcher on civic environmental monitoring for justice. So you will perhaps also hear some words that are not familiar. Please do put questions and curiosity. I'm really eager to hear from you. So my first point that I would like to bring to you is that climate litigation, so court cases surrounding climate matters, tend to be focused on scientific evidence, which is key because scientific evidence are needed to identify responsibilities, causalities, and harm. At the same time, we question some epistemological consideration, in particular, who determines what constitutes valid evidence and whose voices are heard or excluded from climate litigation, in particular, scientific evidence that are presented in such spaces. In Western climate litigation, so litigation that has been mainly situated in the Western world, there is a tendency of a technocratic approach. That is, scientific evidence mainly stem from think tank, scientific institutions, and let's say, so are mainly driven by scientific sources, so official scientific sources, which would not include, for example, citizen science, which has been touched upon earlier. Not even say personal narratives, so lived accounts of climate impacts. One great source that I think some of you may be already familiar is the Sabin Center Climate Change Litigation Database, which really is a key source to understanding the current landscape of climate litigation. And also, it has been pointed by authors, this sort of technocratic trend in climate litigation. I also would like to acknowledge that one of my greatest sources on reversing this trend is the article by the Climate Justice Jean Monnet Center, From Pixel to People, which actually proved how climate litigation can be a way to also foster epistemic diversity. So it's also kind of, there are counter trends, but that this is really the dominant trend. So at the same time, it's evident that civil society are mobilized around litigation, and litigation mobilizes civil society. Van Hala, for example, looked at how law gets mobilized through court cases as a tactic that social actors deploy to address environmental problems. Now, there is clearly a dimension that is, to a certain extent, understudied, which is that of the so-called epistemic dimension of climate litigation. So the knowledge that really gets in. We often focus on the results, for example, who won, who lost, which voices get into the media. But something that could be even more interesting is to understand what has been discarded, what didn't end up in the final ruling that decided, for example, responsibilities over a climate impactful, for example, infrastructural projects. So Yasanov, STS scholar, science and technology studies scholar, frame litigation as deeply institutionalized modes of achieving pragmatic closures around epistemic claims and controversies that science alone could not have settled. And this is already an important contribution because it makes us reflect on the fact that in the end, litigation is a way to negotiate and to kind of push boundaries on controversies that are scientific, but not only. They're deeply political, they're deeply related to democracy, deeply related also to emotions, imaginations, and desires. We also noticed how climate change, and I'm definitely not the one having to expose this to you, but his inevitably complex, polycentric, and has been presented as a legally disruptive phenomenon. So it means that it already requires current practices, including the practices that judicial institutions take, to kind of unpack them and rethink them, because we are no longer discussing about, for example, the pollution causing harm, but rather something that is more polycentric, more uncertain, and somehow more difficult to assess. An example is, for example, that of climate displacement, climate migration, and to what extent it can be said as caused by climate change or other environmental disasters, for example, because to a certain extent it is related to climate change, but there are also multitude of factors. So, going a bit looking at what the current state of the art says, quantitative climate data are central, and we're not here contesting that, but they don't necessarily reflect the lived experience of people daily exposed to the effects of climate change. And this lived experience must be accounted on also through litigation space. This knowledge has been recognized as valuable, for example, by the Platform on Disaster Displacement, which pushed society and researchers to look at climate data gaps, especially climate data from locations that are less represented in official mainstream climate science. Ingrid Boas, for example, also point to the need to combine quantitative climate data with site-specific qualitative data, which she called kind of, I would say, small data, which is also an interesting concept. So the idea is that through climate litigation, we could try to co-produce knowledge that goes beyond mainstream quantitative climate data. And there is an article already out there that I co-wrote with Amelia Burnett, and it's exactly looking at how we can identify emerging cases where personal accounts of climate impacts have been used to decide upon matters related to standing, but also to adjudicate harms, and also to define adaptation strategy based on the civic knowledge shared. This is the article. You're very, very welcome to have a look to it. It's in open access, and it's already triggering a certain discussion on how personal narratives are received by, for example, judges and lawyers litigating climate court cases. These are a list of cases that we reviewed, and among those, so the majority do not cover personal narratives in the litigation itself, but there are two of them would do. For example, Tetiota versus New Zealand and the Torres Strait or Billy versus Australia case. And interestingly, especially the Tetiota case is very connected with climate displacement and advancing current knowledge on the condition under which a person can be considered a climate displacee. We have no time now to engage with all these court cases, but please do engage both in this article and in future research on this matter. Practically, on the idea of climate migration and how this is entering court cases, we have an interesting project that is now concluding called Le Rotte del Clima, Climate Routes, which has been supported by Fondazione Cariplo. There is a report and a policy brief available. And interestingly, and here I'm, of course, pointing only to the arguments that are relevant for this talk, but there's much more. I'd like to stress that there was an interest, although it was a minority, of people to share information on climate events that they witnessed. And they mentioned that they did gather information on the climate events witnessed, but most of them did not use this information to ask for protection in Italy, which means that there is an untapped potential for a number of barriers. For example, they didn't know this information was relevant, or they didn't know that this information could be gathered and valorized somehow. So they shared pictures and videos of a flood, for example, but they didn't keep it and brought it to, for example, the hearing committee determining whether they could be considered a climate displacee. This study focused on potential climate migrants coming to Italy. It was administered to more than 340 participants, and we are still investigating what to do with all the materials because, of course, there is much more than a report. So to conclude, I would like to stress that the inclusion of personal narratives in litigation can address the limitation of an overly technocratic approach to climate litigation, can promote the agency, so the active stance of people, the most affected by climate change, and can also be a way to emotionally relate with litigation and improve public understanding of the problem. Now, from a science and technology study point of view, it seems important to look at epistemic justice in the field of climate litigation, incorporating different knowledge sources and knowledge fields. We looked at how methodological pluralism, combining qualitative and quantitative data, could be an asset for those practitioners working with climate-affected people, and centering data from the margins, which are the data that supposedly are not so visible in mainstream climate evidence. We can shed light and support those contested spaces where knowledge is somehow enriched by a plurality of visions. Now, stay tuned for the project Persona, Personal Narratives in Climate Litigation. I'm going to be the principal investigator, so do reach out if you're interested. And more importantly, we are going to open 4 calls for research contracts and 2 PhD researcher and a technician at the University of Padova. So we're really eager also if you can stay tuned on calls if you're interested. And indeed, the project will exactly look at this emerging field of personal narratives in climate litigation and look to under which condition these evidence are being considered credible in court cases to demonstrate climate harms. And we will do so through a combination of ethnographic approach, legal review, but also a quantitative text mining approach to large numbers of climate litigation. So this is it from me. Many thanks. Thank you for your patience. I know I'm a bit in a noisy place because I was at an event at FAO in Rome. So I think you also heard a bit of the crowded city and noise pollution. So thank you very much.